All rise. The Court of Appeals, Division 1, is now in session.
Thank you very much. Please be seated. This is the time set for oral argument in Haig versus Bill Houston and Brian and Erica Stevens. Let's go ahead and begin with introductions of counsel. Sir?
David Catanese on behalf of the trial court plaintiff Haig, who's an appellant and an appellee based on the record.
Sir?
David Bell on behalf of defendants Houston Agency and Brian Erickson.
Thank you very much. Let me go through a few preliminaries. First, the court obviously has, well, maybe not obvious, but obvious to us, we have reviewed your briefs carefully, and we have discussed in conference this case. So we are familiar with the issues and the arguments you raised on appeal. Each side has 20 minutes, but of course we have here two consolidated appeals, and it appears to me that you may well have already reached some understanding of how you're going to divide your time. Any thoughts on this?
Your Honor, we haven't discussed it, but frankly, I'm willing to argue as the appellee, allowing him the appellant's rebuttal.
Thank you. Thank you very much, Mr. Bell. We appreciate that. We are recording audio and video, the proceedings today. So when you go to the lectern, if you would please restate your name. That way, if someone listens in, they'll be able to identify the voice. I think those are all the preliminaries that I normally go through. I'm just going through a mental checklist. And so with that, we'll go ahead and begin. Sir?
Thank you, Your Honor. David Catanese on behalf of the plaintiffs in the trial court Haig, who are appellants and appellees in this case. And I'll start with our appellant's brief in this case, and that is with respect to the summary judgment motion granted by the trial court against the plaintiff in this case. And the issue was that the court found that there was no issue of fact as to the negligent or the malpractice conduct of Houston, as well as any cause of any damages. I think the record's pretty straightforward and simple. If the trial court had viewed the facts and inferences in the light most favorable to plaintiff Haig, the court should not have granted summary judgment. The easy part of this is the standard of care. The malpractice alleged, as the court will recall from reading the briefs, was when my clients went in, who were from New York, had no idea about uninsured or underinsured motorist coverage, went in and questioned the agent about it. The agent told them with respect to underinsured motorist coverage, you don't need it if you got good health coverage. There's no dispute that that's falling below the standard of care for an insurance agent. Our expert admitted it, their expert admitted it. The question then becomes, did that falling below the standard of care cause any damage? And in this case, when plaintiff went to raise the limits of her liability because state-owned property and the value of the property to increase, she didn't increase her UIM limits to meet the liability limits specifically based on that statement.
But does it matter? Oh, I'm sorry.
Sure.
Just say, but isn't it, if I understand the record correctly, your clients did raise the underlying limits and and added UIM before changing agencies. I mean, so I'm struggling with finding any causal connection.
And that may be with respect to in April when the limits were raised to 100,000. And in that case, for whatever reason, it was
well, not only raise the limits, and I'm sorry to interrupt you, but not only to raise the limits, but if I understand correctly, your client added UIM, which she hadn't had before. She had.
I believe she might have done that. I thought my recollection was that they had limits that were raised of the UIM. She might have done that, but that wasn't because of anything anyone told her. I can't explain why, and we don't know which client did that, because there was the mother and the daughter in this case, and the documents increasing those limits and adding that limit were never provided. We don't know whether it was Ms. Haig or her mother, Ms. Pollock, who did that. But that statement, Your Honor, does exactly what plaintiff is entitled to, not the defense, and that is you're giving the inference that she did that knowing that the liability limits or the underinsured limits were needed and that good health coverage didn't cover that.
But doesn't that hurt your argument then?
I don't, my argument is that in January, when she raises the limits to $500,000, the reason she doesn't raise the UIM is she's under the belief that I don't need it that high because I've got good health insurance. There's nothing in the record to indicate that somebody between the time she was first told that and the time she made the change in January, because that's where the causation is. Causation, we're not claiming that in April there was any causation for the falling below the standard of care. It's the January.
Make sure I understood. You're not talking about a damage that was caused while the Houston agency was still involved.
No.
But you're saying that it was the Houston agency, Patty's, negligent or below the standard of care statement that caused your clients to be uneducated regarding UIM when it came time to change limits after they were with the Stevens agency.
I wouldn't say uneducated. I would say wrongfully educated, because they relied on her statement in January when Ms. Pollock didn't raise the limits to $500,000. She did it based on the fact that she was told something by Barb from Bill Houston Agency. And there's nothing in the record that indicates she was told otherwise, or that when the April 5th liability limits of the motorcycle were increased and UIM limits were added or increased, that she even did that. There's no evidence in the record of that. And second of all, there's no evidence that she did that because some other information had come to her attention or that she was acting any differently. And again, I think when you're looking at the April 5th, that's not the causation. The causation is in January. And if what you're saying...
Could you add the years to those statements so that I could follow?
I believe there's a 2-year difference. I believe it's in 05 of April that the motorcycle limits, and then I believe it's in January of 06. My client, unfortunately, didn't foresee the drop in housing prices, but this was at a time when they were going up, and she was concerned. They were from New York. They owned a home, and that was pretty much it. But the key is in January. And if you're telling me that what she did in April infers that she knew better or that she had some other education, I don't think the defense gets that benefit of the doubt. There's nothing in the record to show that she was informed anything otherwise. There's nothing that she was re-educated. Her testimony is, look, the reason I didn't do this was because of that. And I think the plaintiff should get, as the party against summary judgment, should get that inference in her favor. And from that respect, you've got causation.
Did she testify as to why, after the Stevens agency was involved, as to why the liability limit coverage was raised to $500?
The liability was raised because she was concerned that they had a home, and she was concerned with the home prices going up that the $100,000 wouldn't provide enough coverage. So the liability was raised at that extent. And again, her testimony was, I didn't raise it because of what I was told by an agent. She had a right to rely on her own insurance agent.
Just one other question.
Sure.
Because we're talking about the various contacts here. Were these policies renewed on an annual basis? Because
I believe they were automatically renewed. I don't think there was any discussions. It was a matter of when the year was up, here's your statement, it extends.
There wasn't any evidence about an annual discussion between the agent and...
Correct. There was no evidence of any discussions after that.
Okay. Thank you.
In fact, the only discussions with an agent, Your Honor, are initially with Houston. There are no discussions with Stevens. I would like to save some time, but let me move on to, if I'm correct, we're doing this, the arguments against us as far as the appellee. And in this case, there are two. There is the argument by the defense that all that the agent had to do was provide the UIM form under the statute, and that agent was provided the same protections that the law provides to the insurance agency. For the reasons stated in my brief, especially the fact that there's a huge distinction between an insurance company and an insurance agent, and specifically in this case, this is my client's agent. Now, this agent may serve a purpose to the insurance company, but it's my client's agent.
So you don't buy Mr. Bell's argument that this is a captive insurance agent and that somehow pigeonholes the duty or limits the duty?
Not at all, and I think simply because of the prior cases that I stated in which you can bring a claim against an insurance agent because they're your agent and they fell below the standard of care. I've got to have an expert to testify to that because of the relationship of that agent to my client. There may be some duties to the insurance company. There may be a relationship to the agent. A agency to the insurance company, but that does not obviate the relationship of my client and the agent, as well as those duties that arise from it. As far as the arguments as to extending the protection an insurance company gets under the case law regarding the statute, that all you have to do is provide it, you don't have to explain it, you don't have to interpret it. The recent Wilkes case addresses that. I provided that as supplemental authority in this case. I think Wilkes does a nice job of explaining that the legislature had the opportunity to include agents, that they didn't, that statute only affords the protections provided to the insurance companies and not the agents. The other thing about Wilkes that was
Somewhat different factual setting.
I don't think so in this case, because one of and that's where I was going, Your Honor, and I apologize for interrupting, is that they're very similar in this respect, in that Wilkes, it wasn't just the fact that there was that malpractice, that I'll call it, was simply not explaining the form. As our expert testified in deposition and at trial, the problem was that when that agent has a duty, when any changes are made that come across his desk and he sees them, he has an obligation to look at those. And that obligation includes the fact that when you've got such a gap in coverage, such a gap in protection of $500,000 and $100,000, that should be a red flag that there may be an issue here. And that the standard of care is when that red flag is raised, you need to get a hold of your insured or get a hold of the insured, explain to them, make sure they know what they're doing. That should have been done here. Their own expert admits, yeah, that was a red flag. Our expert says the standard of care is you should have seen that red flag, you should have brought the client in, you would have found out that they were under a very wrong and damaging misconception that their health insurance was going to pick up any coverage in a wrongful death case like this. So in that case, it's like Wilkes. It's not just the fact that you didn't explain it and you would have cleared up the problem that occurred years ago. There was a red flag there that you should have picked up. And I think that even goes beyond the statute. But again, I don't think the statute should apply to an insurance agency. I think Wilkes sets that forth, and I think this court should follow Wilkes in that respect. With respect to the directed verdict, any other questions on the UIM issue?
No, I think I'd like to hear you on the directed verdict.
On the directed verdict, Your Honor, I believe that the trial court made the right decision finally. This is an abuse of discretion standard. I was a bit concerned when Mr. Bell raised it that this is a de novo review. And if we're looking at whether the court should have granted the directed verdict, that may be the case. But his appeal is on the motion for new trial. The one thing the case law tells us is this court treads lightly when looking at a motion for new trial, because unfortunately for you, you don't have the benefit that the trial court has, and that is that you're sitting there, you're listening to the witnesses, you're listening to the evidence. And it's important in this case, and I'm glad Judge Flores followed it, that all I needed was any evidence of negligence. And I really didn't need any evidence of negligence because this issue went to causation.
Can I ask you about that?
Sure.
And I was curious, it's not really just about the fact of some fault. Doesn't the jury also have to have some qualitative comparative basis for fault in order to trigger ultimate access to underinsured motorist coverage?
That may be the case, but in this case, the underinsured was already determined that the fault existed. Because also, remember, the jury heard
Only by the payment? Is that
the full payment of the 100% limits. Now, there are arguments that can be made, Your Honor, that, look, insurance companies do this for a number of reasons. There are reasons in which they would pay without fault. That may be fine. You may know that. The jury doesn't know that. And up to that point in the trial, there was no testimony to that. The only testimony was my client testified how the accident happened. As brief as she did it without objection. She did it without it being challenged on cross-examination. You then had the fact that both repeatedly, opening statements throughout the trial, both the underinsured as well as the liability limits were paid to 100%. If you look at the evidence in that respect, the jury could reasonably find, either you may not agree with it or not, it's not your job, from the evidence of he turned in front of him, the other driver's insurance company paid 100%, her insurance company paid 100%. You can make the argument, and the jury could rightfully come back based on that evidence, that there was 100% fault on my client, or on the other driver. It may be a stretch, it may be by the thinnest of evidence, but as I read the case law, I think it's Brand that says any evidence will permit the finding by the jury. And in this case, whether I might have gotten by the thinnest, it's kind of like when the W goes in the win column. It doesn't matter if you won by a point or you won by 50. You get a W. It's the same thing here.
Well,
Was it would I have liked more evidence? Yes.
Excuse me for interrupting.
Sure.
But what I'm wondering about, which may have been the same thing that Judge Winthrop was asking about, is let's assume hypothetically that you get the check mark in the box at least that there was some fault on the van driver.
Right.
Well, how does that demonstrate to the jury that you're entitled to more than $200,000?
Well, I think at that point they're at 100%. If the defense had come in and with some evidence, had the defense come in with an officer or somebody testifying, here's the way it happened, here were the speeds, then I've got to argue to the jury and they've got to make a factual decision.
You mean it's the defense's burden?
No, I think I've met my burden. I might not have met it as high as I wanted, but turned left in front of them, both limits were paid 100%. I think a jury could reasonably find from that, well, then the other guy was 100% at fault. If the defense then comes in with other evidence, I can come back in my rebuttal, or I can simply argue, here's the evidence and here's your percentage of fault, ladies and gentlemen. Anything else from the court?
Not at this moment.
Thank you.
May it please the court. At the heart of this case is an interpretation of ARS 225901 with regard to what obligation, if any, an agent has to offer, recommend, I think with the words of plaintiff's expert, is to tell the insured it's a really, really good idea to get limits greater than those selected by the insured once the insured is provided the Arizona Department of Insurance approved form through the agent. Our position is the agent has no obligation under the facts of this case to go beyond providing that form. If the insured has the form, can read it, fill it out, and return it. So in the particular facts of this case, as to the motion for summary judgment that was ruled on before the trial, we certainly contend that the trial court properly granted Houston agency summary judgment, not merely because the plaintiff in fact selected equal limits in April 2005 when the Houston agency that was their only involvement in the selection of limits for this policy, but also because the Houston agency complied with the standard of care, or actually the duty, by providing the form to the insured at not only on that occasion, but numerous occasions before. There was a question from this court when, wasn't this the first time that they selected UIM coverage? Actually, Judge Winthrop, that's not the case. At page 21 to 22 of our opening brief for Stevens, we list those occasions between September 2001 and April 2005 when the insureds, principally Jacqueline Pollock, because the testimony is she was making the principal decision maker, when they not only added underinsured coverages to policies that previously didn't have underinsured coverages, but then well before April 2005 brought those policies to equal limits across the board. And so as of April 2005, not merely this Yamaha policy was purchased new with equal limits across the board, but all of plaintiff's policies had equal limits across the board. We also submit that because under Talent and the Ballesteros case interpreting 2259-01B as to underinsured coverage, Brian Stevens should have been granted summary judgment before the trial, but at the trial, if he gets that far, he should have been granted directed verdict as we requested, because the evidence demonstrated that there was nothing conflicting with the insured's decision as presented to Brian Stevens, in that she had filled out the form that says she's read and she acknowledges that she's been told what underinsured coverage is. She's been provided the opportunity to purchase limits equal to her liability limits. That's right on the form she signed. It's checked that she decides to select other limits, and she signed it. Now, there were certainly issues of fact as to how that form was handled. Jackie Pollock saying that was presented to her by the Stevens agency in December of 2005, and she took it back to the Stevens agency. Our evidence being that form was provided to her actually by another agent, and it was delivered to the agency. But I would submit those issues of fact have nothing to do with the material decision on that form. As delivered to the agency, and put in the context as well, Jackie Pollock was quite clear. She did not have any discussions with anyone at the Stevens agency. So this is where factually our case is quite distinct from Wilkes. There was no discussion, there's no evidence of any discussion with anyone at the Stevens agency that would, if you apply Wilkes, alert them that somehow they should be doing something here. What you have is someone who, according to the forms themselves, even if they looked at the file, has had a policy with 100, 300 across the board limits from April 2005 into December 2005. For reasons not shared with the Stevens agency, the insured increases the bodily injury limits to 500,000, and signs the form that says she knows what the coverage is, she's had the opportunity to select equal limits, but she's keeping in place the lower limits. On that record, under 2250, under the statute as interpreted by Talent and by Esteros, and particularly the point that they make that we are to avoid after the fact inquiries into the discussions and the insured's subjective intent.
Do Talent and Ballesteros apply to the agency as opposed to State Farm itself?
I submit that they apply to the agency and to State Farm as well. I think Wilkes, as pointed out by the concurring opinion in Wilkes, oversteps its interpretation of the statute, because if you think about it, as we point out, an insurance company only acts through its agents. If you take the view of Wilkes, or certainly take the view of plaintiff and her expert here, you create the potential that an insurance company can direct its agents, based on Ballesteros, based on Wilkes. We really don't want you talking about these coverages when you present that form. We don't want to create an issue of fact, agents, and so we simply want you to present the form. We're satisfied with that under Arizona law. And if a company did that, and the agents follow that, now suddenly, if you accept their argument, they could still be breaching the standard of care by providing the written form, and following directions of their principal by not going further and saying, "Oh, you selected lower limits. That's a really bad decision." That's their position, and we're saying.
Let me ask you about this. In Wilkes, it cited National Securities versus Johnson as explaining that there's a distinction between an insurer and an agent, and that that 25901 only talks about in terms of an insurer. How do you distinguish what this court held and its analysis of what an insurer is versus an agent in National Securities?
I would point to the subsequent decision of this court in the Miller case, where it says an insurance company can really only act through its agents.
Well, no, excuse me. We're dealing with statutory
Right.
terms. Miller was
Right.
a case in which the insurer sued the agent because the agent had failed to do its job on behalf of the insurer.
Right.
So that's really a very distinguishable case, and in fact is discussed in the Wilkes case. So going back to National Securities.
Okay, and I would distinguish it under in the context of this statute by pointing out that the only way an insurance company can comply with the statute is to have its agents handle those written forms. And in the context of this statute, if the only way the insurance company can comply with the statute is to have its agents handle those written forms, it's creating what I would contend is a impermissible dichotomy.
Then how do you explain away when the legislature briefly in 97 specifically inserted into the protections of the statute a protection for agents and then decided to take it out a year later?
The legislature could look at its own history particularly the history behind the 92 addition to the statute, decide that indeed all along this has been intended to apply to insurers and their agents without the extraneous language of that was introduced in 97 in the record at that time. Look at the fact that the 97 change was adopted because the industry came to the legislature at that time and said the form being used at that time is just too much of a burden. And so they modified it in 98, but you still have, I think, an underlying understanding, I would submit, at the legislature when looking at the 92 history.
Let me ask you, if an agent in some form or capacity defrauded a client, would this statute then immunize the agent from a fraud claim under that, under your interpretation?
Well, I think there you get to Wilkes, and from the standpoint of the insured, there being actual evidence that the insured said, this is what I want, and there being evidence that the agent said, that I'll get you that, and then doesn't get you that. And at least as to, I would say, Wilkes from the standpoint of saying, well, that there is a legitimate issue of fact because of those communications, which aren't protected by the statute. Where you have an actual record of those communications, you have at least an issue of fact that gets to the trial court, whether that's negligence or fraud. But I think here on a record that we have, it goes beyond what the legislature intended in the statute to split the obligations basically of the insurance company and the agent, where absent that type of discussion, for the agent now to put on the agent an affirmative obligation to explain and recommend coverages that the insurance company itself does not have to do in the form. And I think that's where this case goes beyond what the legislature really intended in the statute and as interpreted by Talent and by Asteros. Okay. Now, as to the directed verdict, I'll shift gears to that front at this point. On the record of this case, and again, we go back to record as to the standards under 225901, and on the record of this case as to the directed verdict. The trial court got it right at trial, and it got it wrong on the motion for new trial. If you look at the actual testimony of Christine Haig, and she was asked the question, how did your husband die? Or how did he pass away? And in that context, she says, well, she guesses that the other driver turned left in front of him. She used the term guess, and that's at the day 3 trial, page 172. On that record alone, you have, first of all, evident, obvious, acknowledged speculation by the witness that that's a guess. Under Arizona law, that speculation is insufficient as a matter of law to even create the issue of fact.
Even without a motion to strike that testimony?
Even without a motion to strike, Your Honor. I would say at that point, because the question is simply asking, what's her understanding of how she died? There was nothing at that point to tell me I'm having to address, from that question, that answer, a plaintiff's attempt to prove negligence for the accident. There's simply at that point being asked, the witness is being asked, what's your understanding of how your husband passed away? And in terms of her understanding that he passed away in a motor vehicle accident, she was responding to that question. And I don't think, and I would submit that, for the purposes of my motion for directed verdict, in pointing to that testimony as speculative, as obvious hearsay, which lacked foundation, to be evidence as to negligence, the court got it right to say, that's not sufficient evidence of negligence of the other driver for the accident itself to make your wrongful death claim in the context of a viable UIM claim. And hence, you haven't made your case that there's any damage from his conduct of not providing greater limits.
Forgive me, and I'm sorry, I don't know the answer to this. On cross-examination, did defense counsel then inquire as to the foundation for that? Such as, for example, you were not there. Any information you have, you learned from a third party, anything like that?
Frankly, Your Honor, I believe that was established through other parts of the record, I don't recall expressly doing that in cross-examination, because I believe it was acknowledged in opening statement, or other aspects of her direct testimony, that she wasn't there.
Okay.
I think that was part of the record. And so, whereas here, and in light of Arizona that says speculative testimony cannot make a tort case, and clear hearsay cannot make your tort claim in terms of negligence, the court got it right the first time.
Do we have cases that say hearsay can't make your claim in terms of negligence where the hearsay's been admitted without objection?
I believe so, Your Honor, and we cited in our brief. We have the Owasu versus Hearst Communication. Well, actually, I didn't point to Arizona cases in the brief. I pointed to Owasu versus Hearst Communications, a New York decision from 2008.
What page of your brief?
Your Honor, I'm sorry, I
That's
can't.
okay. I thought you had it
But
there.
but it's there. There's also the Aquino versus Kuczynski case, another case where hearsay alone is insufficient to defeat summary judgment, and plaintiffs has failed to show that there was admissible evidence. So that was.
But that's summary judgment. We have cases in Arizona that clearly recognize that if one is either moving or opposing summary judgment, you cannot rely on inadmissible evidence. You have to rely on admissible evidence.
Right, and for that we pointed to the we also direct you to Owasu, which points out that common law negligence case are dismissed because plaintiffs submitted only hearsay and surmise, only speculation.
That would be at trial.
I understand that they were dismissed. Your Honor, honestly, in looking at the way it's cited in our brief, I have no particular recollection whether it's a summary judgment or trial.
Your argument is that even though the testimony was admitted, and whether it was rightly admitted or not is beside the point, that that testimony by itself is legally insufficient.
Correct.
To make the case. And in that regard, I guess you're arguing that the court abused its discretion in granting the motion for new trial?
Correct, Your Honor. Now, we also have appealed the rulings on Rick Berry or their attorney, their expert, Richard Berry. We raised them largely in the context of if this case does go back to the trial court, if the court does get by the other issues, we submit that the trial court should be directed to deal with Mr. Berry in one of several ways. One, based upon the record we made at his deposition before the trial, we submit that we established through his testimony that what he was offering in this case was purely a personal opinion that without reference to anything beyond his opinion as to what an agent should do, that in his opinion, it's a really good idea for an agent to recommend additional limits when the insured is selecting lower limits. I submit that we had enough of a record there to establish that this personal opinion was unreliable as a matter of law, and the court should have addressed it that way, or at least held a Daubert hearing to go into reliability.
Well, Mr. Catanese suggested, at least in his briefs or maybe even here this morning, that your own expert agreed in this factual setting that a red flag was present and that an agent had an obligation to go back to the client and say, what about this?
No, I would say our expert did not say an agent had an obligation.
But he did it
right.
as part of his personal practice, which then can be considered as part of the standard of care.
Okay. He did, but he also he was very clear in his deposition testimony. He did not believe it was part of the standard of care. And so if the court wants to get in at the trial court, then it has the opportunity under Rule 702 to hold a Daubert hearing and say what's really going on here. And I think we demonstrated through the deposition testimony of Mr. Berry that he has no background in selling these type of policies. He could point to nothing other than his personal opinion that this should occur, that this should be done. And we even went so far in moving for the Daubert hearing, but then and trying to address his testimony in cross-examination to demonstrate that his opinion is actually contrary to the where he says this is a national standard. It's contrary to the law of 23 states that have actually addressed it in terms of a duty. and contrary, specifically as to UM and UIM coverages, and contrary to the law of 8 states that hold that there's generally no duty to recommend levels of coverage. The court, we weren't allowed to explore that at a Daubert hearing, but when we tried to explore that at cross-examination at trial, the court blocked us as well as that. We submit also that the court erred in preventing us from cross-examining Mr. Berry on the Chalabi case, a memorandum decision of this court, but in not being cited in contrary to the Arizona Supreme Court rule as law, but rather if his opinion is there's a standard of care in Arizona or nationally, we should be permitted the opportunity to demonstrate in the case where he was the expert witness that the trial court rejected that the Arizona Court of Appeals had rejected that, because that goes to the weight and reliability of his testimony. In final statement then, Your Honors, we submit that the court should uphold the summary judgment granted to the Houston agency. It should rule that under the statute. Brian Stevens, on this record, had no duty to change or recommend to the plaintiff that she have greater UM and UIM limits other than the 100,000, 300,000 limits selected by Jackie Pollock when she changed the motorcycle policy in December 2005 to January 2006. He had no duty to suggest she do something else. That the trial court correctly then, once we got to trial, if we have to go that far, it correctly held that there was insufficient evidence as a matter of law to make the UIM claim viable. And so the directed verdict was properly granted.
We have two more questions, one from Judge Gimmel, and I've got one I can ask. So
Do I get to go first?
you get to go first.
Thank you.
Okay.
I'd like to go back to the standard of review on the granting of the new trial.
Right.
You know, we do ordinarily say, as I recall, that we apply an abuse of discretion standard of review to the granting of new trial.
All right.
But you're arguing for a de novo standard of review. At least I thought you were in your brief. Maybe.
Well, whereas here, I think you can look at the testimony. The testimony is uncontradicted, so it's not a matter of trying to parse through the testimony. We're looking at the testimony of one witness and whether or not that meets a legal standard of admissibility. I would suggest that this, I think, and I didn't look at this again with our brief says. But I would say whether you apply de novo review or abuse of discretion, you end up at the same point. That it was looking at this testimony where a witness is simply answering a question in this context: how did your husband pass away? And she offers then what is clearly and by all standards both hearsay and speculation. It doesn't meet the burden of proof to prove her UIM claim at issue here.
My question had to do with the language in the State Farm policy that allows an insured, if there is UMI or UM coverage, but the insured has to be legally entitled to collect from the owner of the other vehicle. Boland and Simmons talk about fault, and when I hear the word fault, I'm always thinking Yukata type of fault. And my question is maybe more fundamental. When the policy discusses fault, or excuse me, legally entitled. Mm-hmm. Does it mean then it could be any percentage of fault, or does that mean that the other driver has to have been, for lack of a better term, the person who caused the accident, not in the terms of fault that's used in Yukata, which is, breach of a legal duty plus causation. I'm trying to figure out whether that Yukata tends to taint, for lack of a better term, the concept here, because Boland and Simmons doesn't really address that.
Okay.
Does that make?
I'm trying.
How much fault does the other insured driver have to be? Does it have to be 100% or just some at fault?
I would say, first of all, in this context, there has to be some admissible evidence of negligence on behalf of the other driver.
Okay.
Because in order to make a UIM claim under Volan, again, it is that hybrid type of claim. It may be first party, but it's premised upon the other driver being at fault, being negligent.
So for some percentage of fault.
Correct.
Okay.
So whether, in another context, an insurance company is presented at the outset with a claim and say, I have an uninsured or uninsured motorist claim, and they look at the accident report and the person clearly, their own insured was, by all appearances, 100% at fault. And I've had to address it from a debate, from a context, since I do a fair number of these. Is that a coverage defense and say, oh, there's no coverage here, you don't get it? Or does that become, no, you can open up the claim, but then you're going to go to an arbitration or however it's decided, and there's going to be the trier of facts will decide ultimately who's at fault and how much. And if they could decide that other person has no fault, and so even though you suffered very substantial damages, if they decide that other driver had no fault, you get zero on your claim whatsoever. In getting back to this context, in order to prove that Mr. Stevens' alleged negligence caused any damage, they had to put on some evidence here that there was, some admissible evidence of negligence of the other driver, and they failed to do so.
That's helpful. Okay, thank you very much.
Thank you.
Well, Your Honor, let me start off with that last point. I disagree in the sense that the issue is whether she would have been entitled to insurance benefits, and we know that she would have because both the liability and underinsured paid. It was a matter of how much. And so in that case, there was never any issue that there was any fault. The only evidence presented to this jury that they could base themselves on came from, including Mr. Stevens, who said, yes, we pay UIM when the other driver's at fault. They paid UIM. Faults established. How it happened was provided by Ms. Haig, and while the arguments of hearsay and speculation may sound nice now, he had a duty to object. You're quite correct that on a summary judgment motion, I just can't put in something that would be subject to a valid hearsay or speculation argument. This wasn't a summary judgment motion. This was trial. That was the statement that was made. It was clear, and there was no objection from the counsel or the judge. It was admitted. It was there for the jury to consider, along with the fact that they paid 100% of the UIM after 100% of the liability had been paid. And again, this tethers into what my next question would have been, or my next issue, which would have been how you're looking at this. Because I think it makes a big difference whether this court is reviewing this de novo or abuse of discretion. Because those two reviews are very different. It's a much different standard of de novo. It's a different job that you have to do. It's a different mindset that you have to have in looking at de novo versus what you should, which is abuse of discretion. Despite what he put in his pleadings, I think Mr. Bell has conceded here that your review is an abuse of discretion. And when I read the law of the fact that this court shouldn't be weighing whether, it was evidence, but was it enough? Now we're falling into a de novo review, not an abuse of discretion review.
Let me ask you one
Sure.
question. When you began your remarks in reply, you said that Mr. Stevens had testified we had a duty to pay out if there was fault. Thus, I think the implication that you were making is that they paid out, thus that was evidence of fault. Did he testify to that?
Yes.
Or
And so did Mr. Barry. So did our own expert. They explained what underinsured motorist coverage is. And I believe it's in the transcripts. I don't have the site for you right now, but but Mr. Barry explained it. One of the things we had to do to the jury was explain what these different coverages were. It was explained over and over again, not in an opening statement, which isn't evidence, but by our expert as well as Mr. Stevens, that, UIM is paid for when the other driver's at fault and they don't have enough insurance, and we pay up to that limit you've decided to
You're
afford to
suggesting that this was a closed issue. It was there was no evidence to the contrary, but my recollection is it was identified as a contested issue of fact in the pretrial statement.
Your Honor, that very well might be, and I don't recall the joint pretrial enough to know that. But in any event, I think it isn't, but if it was, I think based on the record of admissible evidence at the time, it was enough that we should have moved on, and the court was correct in saying, you know what, I made a mistake. I'm granting the motion for new trial. And in her doing that with, you may not like the amount of the record, but it was enough that this court can't find it an abuse of her discretion, and that's what you'd have to find in this case. One of the other, any other questions on that? There was another area.
On the standard of review, normally we would normally we would apply abuse of discretion standard to a new trial granting, but I guess it seems to me that would be if she was in a unique position as a trial court to have assessed the value and substance of the testimony, by seeing people and hearing and all of the intangibles that you can get when you're in person. But I don't hear much of that being talked about here. We're limited to one or two answers by your client.
And, Your Honor, I respectfully disagree in the sense that you're asking how much. And I guess in putting a quality on it, you'd have to be at the trial to know how it went, where you're sitting, while you're sitting there watching the evidence, not just the timing that it came in, on the days that it came in, when it came in, all of these things.
How it came in, tone of voice, how persuasive or not, all of that.
Absolutely, the flow of it. Did it come in with her right after Mr. Berry, right after Mr. Stevens had acknowledged that they paid 100%? All of those things you don't have. And the trial court has that, and our prior courts have recognized that's a huge benefit that you don't have, and there should be some deference to the trial court. That's why we've got an abuse of discretion. I think that's why the case law cited in my brief indicate that the trial court should be given deference, and there really has to be an abuse of discretion that strikes you in the face before you decide I'm going to go back now and put myself at a time and a place where I wasn't, but somebody else was that is supposed to make these decisions, made the decision. And so with respect to that, I would say that this is an abuse of discretion rule. When you apply the law in this case, despite the record not being voluminous, it is enough that this court should support and give the benefit of the doubt to the trial judge that was there, that heard it, that recognized it, that deliberated over it and understood what was put in front of her. My time is up. There was one other instance.
We gave Mr. Bell a couple extra minutes. So
the only thing I wanted to emphasize was the word agency, the manner in which it's been thrown around is we've got a specific agent here, because I can go online and I can deal with somebody at Geico that they call an agent, but they're not my insurance agent. I know that. That's an employee of Geico. I can call them up. I can call Geico up. The world has changed a lot how insurance does it. But there are some persons like Mr. Stephen that decides to do it traditionally. Because of his decision to do that, he's taken on an obligation and a responsibility to the consumer. And the one thing that I think a lot of people don't understand is when they do that, they're getting protection. What Mr. Stevens needs to provide is different than if I call Geico or if I call one of the other advertising insurance companies. I've got somebody that I'm hired. You've got a duty to me. I'm your client. You're my insurance agent. And if you do what the defense is requesting and saying, look, no, the agents are just going to be treated like the insurance companies, there's a huge protection that the consumer now loses, that people like Mr. Stevens have a job because they provide it, and they should be required to provide it within the standard of care. As for Mr. Berry, I believe all of those arguments went to the weight of his testimony, not the admissibility. It doesn't matter if there's a national standard of care. It was what the standard of care was in Arizona, and it's beyond my comprehension that both experts agree this is what we do, and their own expert did it for 22 years with an office of 10 agents, and he said he did the same thing. I appreciate the court's time and attention, especially the questions.
One last question.
Sure.
Sorry.
No, that's quite all right. Thank you.
Both Houston and Stevens, were they independent agents?
Yes.
I mean, they were not restricted into what insurance programs they could recommend to clients who walked in the door?
I think they're captive, meaning they're independent, but they've decided they're only going to sell for one. It's a choice they have. That they've decided for the mutual benefits they get from the insurance company that we're going to be an independent agent, but we're only going to sell this company's insurance.
So if I came in, let's say you're the agent, I come in and I say, yeah, I'd like coverage for my home and my vehicles, and you get some basic information. You say, well, I recommend State Farm. And I said, well, I'm not crazy about State Farm. How about Geico? And you would say, well,
You're going to have to go to Geico because my relationship is only with State Farm.
so are they really, is it really an independent agent?
Independent in the sense that they owe a duty to the consumer.
Well, doesn't the duty change? I mean, it seems to me that if you're up front and you say, look, I can't discuss other insurance programs with you, but I can recommend State Farm. It's a great program. I mean,
I don't think the duty changes. Once they say, you know what, I like this, I'm not going to go to Geico, I'm going with you and you're my agent, I think that's why I had to get an expert in this case because of that relationship. The law was clear. I couldn't proceed without an expert telling me that there's a standard of care and this is what's below it. That agency's been acknowledged by the court in the prior cases that was cited.
thank you.
Thank you both very much for your argument and your briefing today.
Thank you.
We are going to take this matter under advisement and issue a decision in due course.